Welcome. It is 11 a.m. on Monday, April 4th. This is panel number 1312, the 27 words in the Second Amendment. My name is Melissa Hart, and I'm moderating the panel. Before I introduce our panelists, I need to tell you about how we're going to do questions and answers in this panel. Audience questions for this panel are going to be submitted by text and 3x5 cards. This is a trial format motivated by a desire to allow our online audience to participate and also to improve the overall question and answer format at the Conference on World Affairs. So if you want to participate in the text question submission, you first need to join this session. In fact, if you think you might ask a question during this session, I'd encourage you to take out your phone now. If you have your phone out, to join this session, and this information is on the sides of the stage as well, but to join this session, you send a text message to the 5-digit number 22333. This is illustrated on the posters on the sides of the stage, and in the body of the message, you'll type the keyword UMCGMB. You'll get a confirmation message that you are now part of the session. Just reply to that message with your question for the panel. If you are a student, please note this in your question. If you would like your first name and your location to be read aloud, please include this information in your text as well, because I'm going to be reading the questions. That's the idea. If you do not have a cell phone, please get the attention of a producer here in the room. I think there's right in the back of the room is our producer. He can provide you with a 3x5 index card and a pencil for you to write your question down. And again, bring it up it'll be brought up to the stage. Finally, please text the word leave when you leave the room to close out your session. And I will mention that again later on. All right, so now I'm going to turn things over to the panelists to make opening remarks. We're going to start at that end of the table and move this way. Our first speaker will be James Viator, who's a professor at the Loyola New Orleans College of Law. Then Robert Kaufman, a professor at Pepperdine University School of Public Policy. Mary Wilson is the immediate past president of the League of Women Voters. And Danielle Steed directs the Madison Initiative at the Hewlett Foundation. And the Madison Initiative is dedicated to trying to make Congress work better. It is actually so sad that makes people laugh so hard. So I'm going to turn things over first, James, to you.
Thank you very much. And this is my first conference, so be gentle. And I'm very happy to be here. I'm going to speak only about James Madison and the Bill of Rights, because to understand any piece of the Bill of Rights, I think we need to start with the father of the Bill of Rights. Madison is not the father of the Constitution. There were lots of chefs in that kitchen, but he is the father of the Bill of Rights. No one else was interested in the Bill of Rights in the first Federal Congress. It was strictly due to his persistence in keeping a campaign pledge to be elected to Congress that his first order of business to get there was to get a Bill of Rights sent to the states for ratification. And he wanted to control the Bill of Rights process because he had particular goals to thwart the rearguard action of the anti-federalists. So a little terminology. Madison was a Federalist. All that meant was we're in favor of this new Constitution. The anti-federalists were those who were opposed to this new Constitution. And their goal in the first Federal Congress was to get a second constitutional convention called because they lost at the first one. The nationalist triumph. And they wanted another constitutional convention to undo the first one. So Madison knew that the Bill of Rights was the opening wedge for that second convention campaign. I've got to get a Bill of Rights sent to the states to stop the anti-federalist second convention movement. So he wanted to write a particular Bill of Rights, one, as he said, that would persuade the anti-federalists within bounds, that is the moderates, to support this government. He wasn't worried about satisfying Patrick Henry or any of the radical anti-federalists, but he had to satisfy the moderates, and in the movement for a second convention. At the same time, preserving the basic nationalistic structure of the Constitution that had been ratified, our current Constitution. And this background is important to understand that opening phrase, which is the battleground in the 20th century and 21st for the Second Amendment, a well-regulated militia. The Nationalists had won the militia battle in the Constitutional Convention in Philadelphia. The central government, the national government, was given authority to have a standing army, to raise a navy, and to control the state militias. The only thing the state militias could do was elect their own officers, but those officers had to train the militia. This is all in Article 1, Section 8. Those state officers had to train their militias, the organized state militia, according to the military handbook written by Congress and using whatever arms Congress insisted. So the Nationalists won that battle. And Madison's goal in the Second Amendment was to make sure that that victory was not undone. So the well-regulated militia phrase, the best translation into modern English would be a well-trained, a well-organized militia. We think of regulation as stopping things, as maybe over-regulation or thorough or plenary regulation. In the 18th century, well-regulated just meant properly organized, properly disciplined. And that phrase was put in there as a sop to the anti-federalists. We realize that there is an unorganized state militia that the national government has not been given control over. But any organized state militia, it's now known as the National Guard, the national government controls. So the whole Second Amendment was a sop to the anti-federalists. The 18th century phrase was a tub for the whale. They're just giving us this Bill of Rights to shut us up. There was a great nautical phrase in the 18th century: when a whale is attacking your boat, throw a big wooden tub overboard, and that will distract the whale. And the anti-federalists knew this Bill of Rights that Madison was proposing was to distract everybody from the Second Convention movement. So what Madison had to do was give this little sop. We recognize that there are unorganized state militias and that they should be well regulated. But notice he says the right of the people in the Second Amendment, not the right of the state militias. Those rights had been taken away at the Philadelphia Convention, and he wasn't about to give them back, because that would be a competing army against the Army of the United States. Wasn't about to give that power back. That's why he says a well-regulated militia, being necessary to the security of a free state, the right of the people. Notice he doesn't say the right of the states. They knew the difference between the rights of individual people and the rights of states. The 10th Amendment and the 9th Amendment talk about the rights of the states. They knew the difference between the two. He's assuring the moderate anti-federalists, you can keep your private arms for private purposes, but there is no state army to oppose us. We're not going to lose that battle. That's why he says the right of the people, not the right of the states or the right of the state militias. In his correspondence, we know what his goal was. The entire Bill of Rights is to focus on the, as he called them, the private rights, the rights of individuals that all Federalists and well-intentioned anti-Federalists agree on. And as my old teacher, Pulitzer Prize-winning Leonard Levy, historian out at Claremont Graduate School, wrote in his book called The Origins of the Bill of Rights, Madison only put in the Bill of Rights the rights that everybody agreed on, Federalist and anti-Federalist. And they all agreed private arms should be secure. No government should be able to disarm the population. That was an unexceptionable, uncontroversial proposition in the 18th century, which is why it got ratified so fast. Madison only wanted to put rights in there that would sail through and scotch the movement toward a second convention. And he succeeded. An individual right to bear arms with no power to the states, no power to the state militia. The only thing the national government now is prevented from doing in the Second Amendment is to disarm the unorganized militia. And people are going to talk later today about civic republicanism, and they'll explain the two kinds of militias. But still in the US Code today, two militias are mentioned. The select or organized militia, the National Guard, under the control of the national government, and the unorganized militia, all citizens 17 to 45 capable of bearing arms. That's the unorganized militia. They cannot be disarmed. But the dangerous militia, the ones that the states run, are totally under the control of the national government. So as Madison said, it's a private right to arms, a personal right, an individual right to arms. It's not a state right. The nationalists were afraid of the states. And the states wanted to overcome the national government by force of arms as necessary. So the militia clauses were crucial in Article 1, Section 8 to preventing that. All power over the organized militias in the states given to the national government. Training, arming, organizing, and nationalizing. Why does the National Guard show up at national emergencies? Because the federal government nationalizes them, thereby controlling them. So we shouldn't be distracted by this states' rights or collective rights argument about what the Second Amendment guarantees. Everyone at the time, friend and foe of the Second Amendment, Federalist and Anti-Federalist, they all knew that it's about an individual right to keep and bear arms, and that that's the one thing the national government is prevented from doing in its control of the militia, disarming the population. Thank you very much.
I told Jim, who was worried he was new, that he was going to be unpopular, that they put me on the panel just to make sure that he wouldn't be the most unpopular person.
Thank you for the service.
Well, that's why they keep having me back. I reassure new panelists that there'll be someone else who'll be the lightning rod. Let me amplify on several of the things that Jim made in his fine points in his fine presentation. First of all, the right of individuals to bear arms that is codified in the Second Amendment had its origins way before that in English common law and is part of Blackstone's commentaries. Point one. Point two is that in modern life, particularly on the liberal side, there's a tendency to think that we privilege some amendments in the Bill of Rights versus others. That's not how people who ratified it saw it at the time. For those who ratified it and for those who voted on it, the right to bear arms was as essential as the right to worship freely and the right to speak freely and the right to retain your own property and the right of contract, because the underlying theory uniting all of these individual rights was that a government strong enough to do any of those things, take those rights away, it was a government that would imperil your freedom, and there needed to be barriers placed beyond which government could go. As Jim pointed out rightly, the Bill of Rights itself was a device to sway states on the balance, particularly New York and Virginia, who were skeptical about ratifying the Constitution, but the Bill of Rights made the difference. Indeed, originally Madison himself, certainly Hamilton was skeptical about the Bill of Rights, but came to the conclusion that ultimately it was not only an expedient thing, but the right thing to do. For the purposes of this audience, however, let me cut to the chase, serving my customary role of telling you what you don't want to hear, but you need to know, and I'll do that with relish. The individual right to bear arms. If you don't want individuals, states and the federal government can impose reasonable restrictions on the type of arms and the conditions for arms, like background checks, akin to the controls on licenses. But if you want to restrict or eliminate the right to bear arms, you're going to have to change the Constitution under Article 5, because 3 recent Supreme Court decisions, District of Columbia versus Heller, 2008, Chicago versus McDonald, 2010, Gaetano versus Massachusetts, 2016, has reiterated the traditional position that the Second Amendment protects the individual's right to bear arms, not only against encroachment by the federal government, but by incorporation from the states. So any modification of the Second Amendment, or any modification of the idea that the Second Amendment permits individuals to bear arms, based on the history of the amendment and based on recent Supreme Court jurisprudence, is going to require and should require a change to the Constitution under Article 5. Let me underscore in my conclusion that Sanford Levinson of the University of Texas, who doesn't like guns, who began a book on the Second Amendment, wanting to show that the Second Amendment did not protect individuals' right to bear arms against the state and the federal government. As much as Sanford Levinson wanted to conclude that, after writing a book on the subject, he concluded that it was absolutely, positively, unambiguously clear that the Second Amendment permitted individuals, not just militias, to bear arms, and that any fundamental change in that right is going to and should require a constitutional amendment rather than some judge under the theory of the living Constitution legislating and rewriting the Constitution in an unconstitutional way. Thank you for your forbearance.
Okay, it's also my first conference, so good to be here. I also appreciate Robert's protecting the one flank or the other. I guess one thing I would say at the outset is I'm cognizant that we're talking about these this amendment and the rights that it protects in a state that's seen two of the most horrific, at least to my knowledge, incidents. And I appreciate that there are people here who may have friends or family that were impacted by those. So as an out-of-towner, I'm treading carefully. I'd offer two perspectives for us. One is going back a bit to the history, and it was very helpful to have the recap of the thinking around the Second Amendment. My reading on the Second Amendment, it's been very much informed by a gentleman who I'd commend to your attention named Saul Cornell, who teaches at Ohio State University, runs something called the Second Amendment Center there. And he's written a very good book called The Well-Regulated Militia, where he seeks to kind of put the context for these laws, going back into some of the laws that were embedded in the state constitutions, and then as they were picked up in the federal constitution via the Second Amendment. And he makes the case I find very compelling that either proponents of individual right to bear arms or those who want to limit those rights are discomforted or put out a little bit by the actual historical context of the Second Amendment. And rather than thinking about this notion of an individual right that inherently preserves this or a collective right that could eliminate it, what he talks about is the extent to which this right as it's described here is more of what he refers to as a civic right, going back to this tradition of civic republicanism to political theorists and people proposing Republican government in England and ultimately to Italy. And the notion of a civic right is one that really combines the right and the responsibility, or the freedom and the obligation. And the reason that this was seen as a civic right is that the biggest threat to liberty in this Republican tradition was a standing army. And so the way to minimize, if not eliminate, the need for a standing army was to have a militia, well-regulated, and I appreciate the point that James made that doesn't mean overseen and managed by government, but highly effective and well-ordered, of freemen who could bring their arms to bear when called upon, and that it was both a right and an obligation of free citizens in a republic to come to the defense of their republic. And so It's to talk about is there an individual right or a collective right, I think overlooks the fact that in the original thinking that gave rise to this, that it was seen as a civic right, and it's a slightly different cast. So that's the first observation, and that's something that's, leads to, I think, frankly, a more balanced position on the issue. I think a second consideration is and I'll offer these observations as a political scientist, the extent to which the national discussion on this issue has really been transformed by the National Rifle Association. And as some of you may know, the National Rifle Association was started in the wake of the Civil War by Union officers who had been distressed by the bad marksmanship of many of their soldiers. And really up through the and it's interesting, in the 1930s, the first federal gun Control Act to restrict the machine guns that were being used by the gangsters in the bank holdups, the NRA testified in favor of that. And really at the time it was an organization that was focused on gun safety, target practice, target shooting, and sportsmanship. And that was really the ethos of the National Rifle Association, really up through the late 1970s. And in fact, they were on the verge of moving to kind of distance themselves from some of the political debates in Washington. They were on the verge of moving their headquarters out to Colorado. And at precisely that moment, in 1977, there was basically an insurrection within the Rifle Association and a group of people who held to these gun rights much more strongly and wanted to press their case vis-a-vis the government, really basically replace the people who were more focused on sportsmanship and gun safety, and really reposition the organization as an organization that was focused on gun rights and zealously, and I think it's hard to argue quite effectively defending those rights. And one of the things that they were pressing, and I'll take issue with my predecessors here slightly, the notion of an individual right to bear arms was something that really up through the 1990s was not seen as widely recognized, even by conservatives. So in 1990, Justice Warren Burger, a conservative Chief Justice of the court, referred to this idea as a fraud based on his reading of the Constitution. And that was really where the court had held. Now, it's quite clear more recently under the Roberts Court, with the decisions that Robert mentioned, that right now is woven into jurisprudence. So that right has been secured through a series of court decisions and through I think the intense advocacy of one particular group. Now, I think the upshot there, for those of you who want to see some balance or moderation in these rights, is this notion of a countervailing force. I think it's fair to say, I think one of the reasons that the National Rifle Association has so much influence is, and people will say, well, what about the money and the campaign contributions? It basically stems to the fact that a lot of members in the National Rifle Association feel very strongly about their gun rights and communicate that to their members of Congress. The opposition or the counterbalancing force on the other side of that issue to date hasn't really registered. It's not as organized, it's not as determined, it's not as vehement. So I think from a political perspective, to adjust the balance in gun control and gun rights, this debate, I think it was going to require some sort of countervailing force in the public sphere. There's some groups now that are starting to do that, but I think they will have a way to go. I suspect there are members of the NRA in the room, and I think they can attest it's a very well-organized and committed group that cares about these rights that are fundamental in terms of their treatment in the Constitution. And I think you'll need to have as concerted and well-organized action on the other side to get the pendulum back in the middle. Thank you.
I have the pleasure of being the non-expert on this panel, and so I come with a lot of questions. To hear my colleagues here discuss this, you'd think it was settled, and why even bother having this panel, because the right to bear arms in the Second Amendment has been declared to be a fundamental right that cannot be taken away from the people. I would hurry to note that both the Heller and the McDonnell decisions were 5-4 decisions. So there's some room there for those of us who feel that there are way too many guns out in the public and that we need to have stricter controls in order to protect the health and safety of the people. It's quite true that contrary to what a lot of us hear in the political rhetoric that's going on right now, there's no one out there that is going to try to take your guns away from you. It's true that after Heller, the Supreme Court decision in Heller left a lot of room for the states to regulate and the federal government to regulate with respect to who could have arms. For example, felons and the mentally incapacitated still can be barred from owning guns. There's also a lot of room with respect to the registering, the requirement to register guns. So the Supreme Court, yes, while it did declare that the concept of the right to bear arms under the Second Amendment was not restricted to the militia situation, they left a lot of room for regulation for health and safety purposes. And so it boggles my mind as to why anyone thinks that some of the regulations that are being proposed at the state level, state and federal level, can be construed as being, oh, the state's trying to take my guns away from me. And let me say that I live in a rural area of New Mexico, a very conservative rural area of New Mexico. And I cannot quite understand why a lot of the people in my particular community have this loving, close relationship with their guns. But they do. And my husband and I had an interesting experience a few years ago in some members of the NRA in our particular area wanted to establish a gun range very close to our home. And we utilized the zoning restrictions, which were quite permissible, to look into and put some restrictions on the gun range. Those kinds of things have not been prohibited by the Supreme Court case. However, it gave us the wonderful opportunity to see that close relationship that people had with their guns. And so while it might be the NRA's original purpose to make sure that people could shoot straight, so to speak, what we saw in that particular exercise in our community was that people wanted to keep their guns under any particular circumstance, and they really didn't want anybody saying anything to them about particular restrictions that they might have placed on them. So I think there still is a real problem with respect to the public's approach to what the Supreme Court has done in terms of this Second Amendment right, carried vastly too far in terms of what the case actually held. And I certainly welcome some discussion amongst the panel members about that particular issue. And also amongst my neighbors in the conservative area that I live in, there is a real opportunity, if you will, for certain politicians to make more of the gun issue than is really there. And to try to use that, oh, they're going to take my guns away approach in order to try to make some hay in their particular philosophy in the election. And so we see it from, we out there in the non-expert world see it more as a political issue than as a legal issue, I think. because we hear this rhetoric all the time from people who are running for our state legislature, trying to say that they're the ones that are going to protect the people's right to have their guns under any circumstances. We also, in New Mexico, and I'm sure that many of you in your other states, and as Dan has mentioned, the concept of here in Colorado, you've seen some extreme violence. We have experienced all over our state what I would call one-on-one types of violence. We haven't had the mass massacres that you've experienced here in Colorado, but we have a huge problem with thugs shooting thugs and police shooting thugs. And the concept that everybody needs to keep a gun underneath the seat of in their car just boggles my mind. Are you really and truly expecting someone to come after you with respect to what you might do in your vehicle so that you have to protect yourself when you're driving in your car? I really think not. The household protection issue in this day and age where there is a lot of break-in and in the home and so forth, that's one perspective. But all of these people who carry guns in their vehicles has caused a lot of serious damage across the country with respect to one-on-one violence just because of the road rage concept that we experience. So there's a lot of room for regulation for what I would refer to as the health and safety of the general public. Thank you.
All right. Well, based on the questions that I'm getting texted, I can see why they thought that having questions texted rather than asked right out loud might make sense. There are some great questions, too.
Hate speech. Hate speech.
Two of you so far have inquired whether the panelists think that there's some compensation going on when people buy guns. I won't elaborate further. But a number of people have asked a variant of the question and have posed it particularly to Professors Kaufman and Viator. What do you think constitutes reasonable regulation of guns? We acknowledge that some regulation is permissible. The Supreme Court, in creating this individual right to bear arms in 2008, said that reasonable regulation was possible. If we look at the analog in the First Amendment, even though both say Congress shall make no law essentially restricting these rights, we know that in fact lots of laws restrict rights to free speech and that they just have to be justified. So what kind of regulation is justified under the Second Amendment, and how do we assess that?
Before I do that, I want to do a poll. How many of you good people out there are for Bernie Sanders? Well, I spent 12 years at the University of Vermont, including preparing his debate opponents, and do you know that on the issue of gun control, Bernie Sanders votes right down the line with the National Rifle Association. So I thought I'd alert all of you good people to that paradox before I commented. Now, in terms of restrictions, I'll follow Aristotle's remark that the mark of intelligence is to make reasonable distinctions. Can you regulate people having guns who have criminal records, minors, the way you wouldn't put a vehicle in the hands of someone who had a DWI? Sure. Are people entitled to an aircraft carrier, a missile defense system, an armored division? No. Can you make reasonable distinctions based on personal firearms versus assault rifles? That's a reasonable distinction as well. But what the Gaetano case did say, even though it did not specify the extent of permissible government regulation, is that there are bounds beyond which the government, state or local, can't go, and you're not bound in protecting those rights, according to the court, by the arms that were available in 1789. So it's a reasonable person test as to what types of restrictions a government can impose for health and safety, the way you impose it on automobiles and other things. But there is, based on the history of the amendment and the Supreme Court decisions, there are bounds beyond which you can't go. There's another response I have. If you don't like the gun laws, fair enough. That's why we have a political process, and it's reasonable to fight it out. The Constitution provides a way of abolishing the individual right to bear arms. That's Article 5 of the Constitution, amended. If, however, you can't amend it because you don't have the support for it, then you're going to have to live with it if you're faithful at all to the original meaning of the Second Amendment and the history of the jurisprudence to that effect. Reasonable restrictions are permissible, but nothing that would eviscerate that fundamental right is consistent either with the history of the amendment or the modern jurisprudence on the subject.
So that actually, I'm gonna, and I think again, this could go to anyone, but maybe particularly to you, Professor Kaufman.
Another year to me. Go ahead.
So a number of people have asked if the meaning of the Second Amendment as encompassing an individual right to bear arms is so clear, why did it take until 2008 for the Supreme Court to recognize that? Because all of the Supreme Court's decisions before that did not.
For the same reason that after the passage of the 14th Amendment, providing equal protection of the laws to all African Americans nationwide, but more particularly in the states in rebellion. For exactly the same reason that it took almost 100 years for the Supreme Court to say, you know, separate but equal is not what they were talking about in the 14th Amendment. In other words, courts can be wrong too. And when a court is wrong, it's not like one person changing their mind, it's 9 people changing their minds. Get 9 people together today for lunch and see how long that takes to eat at the same place. Courts can be wrong, and often are wrong, as the history of separate but equal sadly proved.
All right. Does anyone else want to say anything about that?
I'll just take a stab at saying that if you look at how our nation evolved and how society evolved, you will see that in certainly more recent years, last 30, 40 years, that's when we have seen more gun violence, more people, average ordinary citizens, having guns for their protection, and more attempts by the different states and localities to restrict gun ownership in some respects. And so that's why it took a District of Columbia strict law, if you will, before that one bubbled up to the Supreme Court. So it's kind of a function of our society of evolving from the way I see it.
Evolving toward the correct answer, I would add.
So I want to say to everyone in the audience that some of these texts are coming through sort of ending right in the middle. I don't know if there's a character limit. A few of you have sent texts in multiple message frames, so I think you may, if it's a very long question, you may want to break it up into 2 or 3 pieces, because some of them just aren't complete questions. Or you could raise your hand and ask for a card, and the producers will bring you a card. Let's see, how about, Mary, the question comes from Joan. Has the League of Women Voters studied the Second Amendment and taken a position on amending it?
No, we have not, and that's a very good question, and I was going to mention in response to what Robert said, those of you who in the audience who don't particularly like the Heller opinion and think it should be overturned. Don't bite into the rhetoric of changing the Constitution on that particular issue. It won't result in the right answer for you.
Okay, here's a question from someone who identifies herself or himself as a doctor. Why does the NRA oppose research on gun safety by the CDC? The questioner goes on, as a physician, I have seen many epidemics appropriately addressed and lives saved through research, and we in the U.S. are experiencing an escalating epidemic of gun deaths.
I presume that's to me?
It wasn't directed to anyone.
I'm not a member of the NRA. I don't own a gun. And the NRA, however, under the First Amendment and freedom of speech, has the right to organize every bit as much as you do. I am going to say one thing that will be an additional thing you won't like. There's absolutely no data whatsoever to confirm the position that stricter gun laws reduce violent crime with firearms. On the contrary, the District of Columbia has had, for the last 40 years, the toughest gun laws and the highest incidence of crimes committed with firearms, whereas the not-so-great state of Vermont, where I hope I get credit for purgatory, at the last judgment, I spent 12 years there, has some of the lowest crime rates of violent crime and some of the loosest gun laws. So as to why the NRA won't do it, I have no contact with the organization. I don't know. But my response, if you don't like the NRA, organize on the other side. This is freedom of speech. They have the right under the First Amendment to make this case, and this case has a constitutional pedigree that there is an individual right to bear arms. If we come to the Scalia panel later today and you want to be further offended and see how much I admire Scalia for his originalism, welcome. An originalist would say that anybody ratifying the Second Amendment in the 1780s understood the Second Amendment. That's what they understood they were ratifying as the right for individuals to bear arms. You may think they're wrong, you may think that needs to be changed, but the way to change it is through the political process and constitutionally. The ends don't justify the means.
Oh, okay. Okay, this is a question from a student. Is it a crazy idea to consider infecting the NRA with a bunch of not necessarily anti-gun members, but pro-gun safety members, sort of a back to the 70s? Why not work from the inside? Why not send in a tsunami of, intellectuals?
Let me respond to that. There's a dynamic here that in some ways is quite apart from the policy issues, and you can almost think about interest groups and advocacy groups as entities that need to find a way to flourish, and groups like the NRA find typically that it is much easier to raise money from members by getting them riled up. And I will say that there is you can see why members would happen to think that people don't really believe that they have a constitutionally grounded protection to keep arms. I think that there's something about the dialogue here that leads reasonable people to conclude, and I think you could look to President Obama's unfortunate statement in the 2008 campaign about, I think it was the voters of Pennsylvania who were kind of caught up in their religion and their guns, and there wasn't much he could do with them. So there are aspects of this being a cultural battle, and I think the NRA plays on the fears of people on one side of that, or the fears or the concerns, plays that like a well-played instrument. So you could conceivably make a pass at trying to infiltrate the NRA. I suspect that there might be more fruitful paths of organization, because the way that the NRA is organized, it is to take those unstinting positions and to see anything other than that as a compromise that was likely going to slow down the financial contributions and the membership dues as it's currently constructed.
Great. So this is a question from a student. I think I got this by text too. I think it's a student from Palisade. Given that one of the inalienable rights that is upheld by the government is life, and also given that when handgun bans were put in place in places like the UK and Australia, we saw a really massive decrease in the amount of suicide and the amount of homicide as well. Does the right to bear arms butt up against and perhaps not take precedence over that inalienable right to life? And would that give some measure of right to greater regulation?
Could I answer that one?
Mm-hmm.
Part of the number of the inalienable rights mentioned in the Constitution and in the Declaration of Independence, life, liberty, property, pursuit of happiness, that government does not grant. They only exist to protect. As Jefferson said, individual rights come from nature, and nature's God, not from governments. Governments are the great destroyers of rights. Have you noticed? So our government is pledged to protect rights to life, liberty, and property. But sometimes the government isn't there. As I like to tell my students, when seconds count, the police are only minutes away. So part of the right to life, as Blackston said, as the Civic Republicans said, was the sacred right of self-defense. And that means effective self-defense. So to the extent that arms are made difficult to acquire, ammunition difficult to acquire, to practice with, et cetera, et cetera, et cetera, isn't the government impeding the right to life? So don't think of life as just something the government gives by regulations. It's something the government can take by regulations, by impeding the right to self-defense. And by the way, in the civic Republican tradition, I think the professor will agree with me, there were 3 types of defense. They were all contained within the virtuous citizen who was armed. Protect yourself and your family against felons, invaders, and tyrants. And that's what the individual right to keep and bear, which means you got to leave your house to bear them, maybe even be on a wagon, a horse, or in a car. The right to keep and bear those arms was to protect that threefold right of self-defense: felons, invaders, tyrants.
And to amplify on that point, the civic Republican tradition is not the dominant tradition of American constitutional interpretation. The political theorists most cited by the Founding Fathers and the debates at the time wasn't civic Republicans, it was John Locke. And John Locke's state of nature provided the inalienable right for effective self-defense. So it's not just a civic Republican right. It's a right grounded in the Lockean tradition that is really foundational to the American Constitution. People may not like that, I do, but the pedigree of the right of effective self-defense goes long and deep and wide beyond the civic Republican tradition, all the way back to English common law, and is a fundamental precept of Locke's state of nature.
So we've gotten several questions along this line. This is from a student. When the Second Amendment was written, guns were significantly different from what they are today. How can we justify upholding an amendment that means something very different today? Owning a semi-automatic weapon is vastly different than owning an 1800s rifle.
So could I take the first pass at that? Hold your applause till I finish, please. So we do know a lot about the weapons that were considered appropriate for individual self-defense or defense of the community against tyrants and invaders in the 18th century. And they were sort of akin to what I think a lot of people still think of as personal weapons. First of all, you've got to be able to bear it, carry it. Bearing in the 18th century meant to carry on your person. No tanks, no B-52s, all right? But you can carry a long gun. You can carry a pistol. And if you look at the militia regulations of the states in the 1770s, 80s, 90s, and even the first Militia Act of 1792 for the federal militia, notice Madison said arms, not firearms, arms. Militiamen were expected to show up with a long gun and a tomahawk. The officers were expected to show up with a pistol and a sword. Those are the sorts of weapons one can bear and use appropriately for self-defense against felons, invaders, tyrants. So what would be the analog to the long rifle, the musket? Some kind of rifle. Automatic rifles are been illegal for a long time. Single-shot rifles, is that effective for self-defense? Does everybody shoot that well? How about repeating rifles? Is that effective for self-defense? I think that's the kind of questions you have to ask.
I think it's important for all the listeners to understand that the courts have very definitely said that it doesn't matter that you have more modern guns than you did then. And that's really the essence of the March opinion this year that said stun guns were protected under the Second Amendment. So they're really not making that distinction in terms of, well, were the guns available then?
A couple of people have asked about different types of regulation. Here we have a question from a teacher who asks, how do magazine limits infringe on the right to own guns?
I don't think they do. I think by analogy to, and I think to be thinking about regulations, you should look at the kissing cousin of the Second Amendment, the First Amendment, and think about the way regulations are superintended. So that if a regulation is attempting to suppress free speech, it's unconstitutional. If it's a reasonable and neutral time, place, manner a regulation, you can't stand up in the university and start speechifying except in these times, and neutral, every person of every political persuasion can do it. Those kinds of regulations would pass muster under strict scrutiny of the Second Amendment. But any regulation that is designed as a pretext to impede the keeping and bearing of arms for self-defense, et cetera, the court would strike that down. So as long as it's a non-pretextual regulation and doesn't impede with self-defense, do you need 22 shots for self-defense? Probably not, but you probably need more than one. And somewhere in between are the grounds for the regulations that are not a pretext to impede self-defense.
Okay. What about, someone asked about registration, stricter registration rules requiring people to register their guns. Is that a pretext, or do you think that's a reasonable regulation?
Yeah,
And the flip side of that, I guess, and this really is, I think, to everyone, how does that help control gun violence?
registration, background checks, that's all reasonable. We do that. We don't, everybody has a right to vote, but if you're a felon, you don't, because you lose the right. Your right to operate a motor vehicle can be taken away. Registration requirements, criminal background checks. I actually think even requiring training in gun safety, the way you have to pass a driver's license, that does not impede the fundamental right to bear arms, because under general nuisance law, that right would be conditioned on your ability to handle something that's potentially dangerous in a safe manner. So those types of restrictions, again, going back to James's point, would be to enhance the right and not to eviscerate it. So registration, safety, background checks, disqualification for criminal records, none of this would be, I think, objectionable to a large majority a Supreme Court in a Second Amendment case.
And I might add that these kinds of things that these gentlemen are describing as reasonable, there's been a plethora of cases challenging different regulations since the Heller and McDonald opinions, and those kinds of reasonable regulations have been upheld. At least from the perspective that I see it is the concept of getting some of these tighter registration and regulation requirements that are constitutionally permissible. The problem with getting those is through the state legislature, because you have this political viewpoint that any kind of regulation is going to do harm to the political future of the state legislator who votes in favor of it. And I speak because of the New Mexico state legislature for the last 4 years has tried to pass these kinds of reasonable sorts of restrictions. And there is not the political will amongst the legislative body because of what I think is a misperception amongst the general people about whether or not they would want these kinds of reasonable restrictions.
Mr. Steed, I have a question for you that, again, combines a few questions that are being asked. A number of people have been writing asking, where does the NRA get its funding, questions about the NRA. Since none of you are actively here representing the NRA, I guess I want to reframe the question and ask you, as someone who studies and works with Congress, do you think that federal regulation of guns is something any of us in this room can expect to see in our lifetime, or do you think that the capture of Congress by the NRA is so absolute that that's just not going to happen?
Over and above existing law.
Right.
Yeah. It's a good question. To me, and I just want to make one observation before answering it, is the extent to which, once we moved away from the constitutional issues, is there a right, isn't there a right, and started talking about kind of permissible regulations or fixes, that I think there's a consensus, I would say, emerging, or there's one that you can describe up here. I think there's one that you can describe, broadly speaking, among most Americans, which is that there is a right, but that it needs to be regulated and can be done so in a way that supports public safety. So, I think this is an instance where the advocates, particularly on one side, but in reaction on the other, especially in the wake of incidents, revert to first principles, and that kind of clouds the discussion or the debate. To me, this is a matter that the states and localities, which are going to have different registers of the prevailing opinion within them, are much better equipped to deal with. I think it remains the case, and I think the political power of the National Rifle Association comes from the fact that they have dedicated members for whom this is a big issue, and they communicate that to their legislators. And the people who are on the other side are not as pervasive in their influence. I think there is a couple of structural features of our system that might tip the scales a bit. One is certainly at the federal level in most state governments, rural areas tend to be a bit overrepresented by dint, for example, the federal level at the Senate. And so generally people more supportive of our gun rights tend to be more based in rural areas. But to me, there's never, I think Robert, there's never going to be an overturning of this amendment. So the question is, how do we live with it? How do we balance the different things within it? And I think there are ways forward for people who are organized. I want to come back to I want to give a better answer to the student who asked earlier about the infiltration of the NRA. So there may not be something there, but here would be a hypothesis to test, which is the unstinting positions that the NRA and there are other groups, that are to the I would say the closer to the pole than the NRA around gun rights. So we're using that as an example, but there are multiple groups taking this hard line. One of the things that can happen in an organization like that is that the advocates and the lobbyists actually take positions that are much harder in line than a good chunk of the members might support. And so I grew up in a farm in Michigan. I grew up hunting. A lot of my friends who are still farmers there are hunters. They're NRA members. And, we talk a lot about this and the extent to which, I sometimes will see something posted and I'll say, is this, you fully on board with this? And so I think, what's interesting is that there are sometimes a very effective advocacy play is to appeal to members of a grassroots organization that you feel the leadership is taking positions that are out of step. As a way of kind of checking or bringing some accountability, because most people, they are joining these groups as much to get the hat and the license, it's kind of a affiliation. They aren't lock, stop, and barrel for all the positions, although a core group are, and the most vocal of NRA members are. So there may be some way to kind of start to expose a rift between the national leadership and the membership. I just don't know to what extent that could pay off.
Are we being a bit hypocritical here and demonizing the NRA? Believe it, well, believe it or not, there'd be many people who would say that organizations that lobby for pro-choice take much more extreme positions than the more nuanced public positions of the American public at large. Are they illegitimate? Should we infiltrate those groups? Or is part of freedom tolerating and encouraging people exercising their First Amendment rights? It doesn't seem to me that the NRA is doing anything different than all sorts of interest groups on the left that many of you probably cheer about, only in this case you just don't like what the NRA is doing. But understand that when you restrict somebody's speech, or if you're infiltrating one group, or you're saying that the NRA is doing something fundamentally illegitimate that everybody else does, that will come back to bite you as well, because what goes around comes around. If you don't like what the NRA is doing, out-organize them, but they are exercising in a legitimate way their legitimate First Amendment rights, and it's dangerous to treat them otherwise.
So to be perfectly clear, I think Robert and I are in radical agreement.
I take it back.
Okay. I would concur. I think the NRA is a very effective advocate for its positions. And I think that the solution is organizing countervailing force, which people have right to do. The observation I was making about whether the NRA as a group is a national advocacy organization is taking positions that might be outside the median view of its members is just an observation that almost all organizations that are advocating policy positions tend to assume positions that resonate with a subset of members that are most apt to be supporting them economically. So that was just an observation about the sociology of organizations. I think again the key, if you don't like what the NRA is doing, organize against them.
All right, a couple of questions have come in around sort of this general theme. A little while ago, a question came in from a person who identified himself as a trained military policeman, who said he thought that the notion of competent self-defense was a fallacy. So I mentioned that, and then add that to this question. In the discussion so far, the emphasis has been on using guns for self-defense. Data show that deaths due to gun accidents and suicides far exceed lives saved by persons using a gun to protect themselves from the attack. To what extent should this data be taken into account in establishing gun regulations?
First of all, that's not good data, because most times when a weapon is drawn in self-defense, it is not fired, but the attack is broken off. That never shows up as a crime statistic. Well, thank you, sir. I'm from the farm. I have seen lots of bullshit. I used to shovel it. But that's the way statistics work. It's like saying the death penalty prevents murders. You can't know that, because if it does, that murder never shows up as a statistic. So studies done by private universities, not funded by either the Soros Foundation or the Koch brothers, have shown that most times a weapon is brandished in self-defense, the attack is broken off, it's never fired, no law is broken, nobody gets hurt.
Well, what what is, more generally, I guess, then I think a number of people have asked questions about how we should take into account, how we should think about the reality that guns are often used for suicides. And does that factor into how we think about regulation?
Let me reiterate. All the Second Amendment says is that the population cannot be disarmed of the weapons covered by the Second Amendment, capable of being borne on the body and used for self-defense, defense of community against felons and tyrants, okay? That leaves a lot of room for regulation. But you are always going to be disappointed if the goal is not one person will use a weapon for suicide. Because like any other useful instrument, including the Mississippi River Bridge in New Orleans, it can be used for good and evil. More suicides off of that bridge than by gunfire in New Orleans. Should we get rid of the bridge? Any useful implement can be used for good and evil. And if you think you're going to stop the evil uses, then necessarily you have stopped the good uses. No more Mississippi River Bridge. That's the way to think about this. If your goal is perfection, you will always be disappointed. I want to thank the people from Louisiana. Thank you very much. Damn bridge is too crowded anyway.
I have a couple of questions.
The G&O.
A couple of other questions from students. One student asks, as a world power, and specifically says this is to all panelists, as a world power, does the U.S. have a responsibility to consider how our gun laws affect other countries? Mexico's cartels, for example, get many of their guns from the U.S.
If you want to worry about guns pointed at us that are serious, I wouldn't worry about handguns. I'd worry about Iran's missile program. I'd worry about China's anti-ship capability that's going to deprive us of the ability to operate in the Pacific. I'd worry about the Russian military buildup that is now compromising NATO and the power vacuum in Europe. If you're asking about what we need to do as a world power, let me quote Demosthenes to the Athenians regarding appeasing Philip of Macedon. We have to stop doing what we're doing now and act as the world's default power the way we did in the Reagan years. That's the answer. That is the answer. The answer is the handguns, the question was, as our status as a world power, what is the number one priority? I was kind enough to answer that for you.
So if I can, I think the issue around questions around, for example, suicide or the influence on other countries, I think what they keep bumping into is that this is a constitutionally grounded right. And so there are a lot of reasonable considerations that can be raised, but it's hard to kind of translate them into meaningful public policy. I think the way to meaningful public policy is to accept that this is a constitutionally entrenched right and then to turn to those elements of regulation that are much closer at hand and that we've been talking about even from the advocates on the panel. That strikes me as a place to turn to.
So on that front, actually, a number of people have asked, and here's a question from a student, curious what the panel thinks about having gun-free zones, such as schools, airports, courthouses. Is that reasonable regulation or not?
It will certainly pass constitutional muster. It's a reasonable regulation. I'm not sure it's a good one. Because where do the lunatics with guns generally show up to kill people? Police stations? No. Gun-free zones, schools. So I'm not sure. It's certainly constitutional regulation. I'm not sure it's a wise regulation. Yeah.
Guns in the Republican convention.
Absolutely. Mandatory concealed carry permits.
That's a serious point that I'm not sure about schools, but one of the things that made the shooting spree in 2009 in May at Fort Hood by Major Hassan so deadly, 15 killed, 48 wounded, was that the base was operating under a prohibition of the military carrying their firearms. So there are situations in public places where actually, sadly in this day and age, the lack of firearms could lead exactly to the opposite result as an unintended consequence, and Fort Hood is a glaring example of that.
I mean, clearly the Constitution would allow those kinds of restrictions in different places. Let me tell you an interesting little anecdote. 4 years ago, I think it was, when major legislation was put forth in the New Mexico State Legislature in Santa Fe, when there was a committee hearing on this particular provision, most of us citizens learned for the first time that you could carry guns into our state capitol where the legislators met. We always knew there were no metal detectors or anything going into our state capitol. We just never thought about the concept that people could carry guns into the capitol. Well, of course, when the committee was meeting to hear these restrictions on gun control issues, everybody who was, well, not everybody, but the vast majority of people who were opposed to that regulation decided to carry their guns that day. It did have an intimidating effect on the people who were there to exercise their freedom of speech, to speak in favor of regulating guns. So, you can look at that issue from all sides.
And that's it. It's interesting. One of the questions that we got earlier was, does one person's exercise of her Second Amendment rights butt up against another person's exercise of her First Amendment rights? So that can sometimes.
Well, every right in the Bill of Rights, if extended indefinitely, bumps into another right. Free press rights interferes with a fair trial right. And so the job of courts is to balance and adjust so that neither is excessive, but that both can be properly enjoyed.
I have, again, just sort of, I really liked Daniel Steed's reminder to us that because as of right now, the individual right to bear arms is grounded in the Second Amendment, thinking about what regulations are reasonable.
And it's not conceivable to see that changing in terms of the constitutional status. The idea of an amendment to overturn that, just politically.
Okay,
Yeah.
I'm putting my finger on the question that I was going to ask, and
Okay.
I'm now going to ask a different question
Okay.
that several of
sorry,
you
I
have.
didn't mean to.
No,
Yeah.
that's good. I remembered that
Yeah.
I wanted to ask this
Yeah.
question earlier. So several of you have asked, kind of along the lines of an earlier part of our discussion, DC against Heller, which was decided in 2008, was the first time that the Supreme Court had recognized an individual right to bear arms. It was a 5-4 decision. Justice Scalia was in the majority. If the issue comes to a new Supreme Court, if we ever have a 9-justice Supreme Court again, if the issue comes to a new Supreme Court and that Supreme Court finds that Heller was wrongly decided, do we say that the intervening 8 or 9 years of law were wrong? Do we say that court was wrong? How do we make that decision? And is that, in fact, the way to change things? Not an amendment of the Constitution, but in fact a change in the composition of the court.
I have to say that that's a wrong-headed way to think about the Constitution. That the court, with ever-shifting sentiments and personalities, is some sort of continuing constitutional convention that rewrites it under political pressure and motivations. That's a fundamentally anti-Republican, lowercase r. That's a fundamentally, you're not living in a constitutional democracy if that's how you think about the Supreme Court. As Abraham Lincoln said after the Dred Scott opinion, preventing Congress from outlawing slavery in the territories. Abraham Lincoln said, the Supreme Court has made its ruling. It binds the party's litigant. Mr. Dred Scott is still a slave. It binds no one else. Litigation only binds the party's litigant. And Lincoln also said, to the extent that we, the people, surrender our ability to make great decisions and allow the court to make those decisions for us, to exactly that extent, we are no longer a democratic republic. So I say, to be pro-democracy, as opposed to judicial aristocracy, you should take seriously the ability to first pass statutes, and secondly, amend. If you can convince your fellow citizens that on balance, the Second Amendment does more harm than good, but you'll also have to repeal the 14th Amendment. Because McDonald versus City of Chicago said the states are bound down by an individual right to keep and bear arms for self-defense. And they're absolutely right about that. The debates in the 39th Reconstruction Congress talking about how do we protect the freedmen from the Ku Klux Klan, the Knights of the White Camellia, and corrupt Confederate officers who are now sheriffs in those states. What do we need? Time and again, they said, first, the freedmen need the First Amendment. Speech, press, petition for redress of grievances, all individual rights, in order to persuade the government to protect them. But when that fails, the freedmen need the Second Amendment right to keep and bear arms to protect themselves from the Knights of the White Camellia and the Ku Klux Klan. So if you're talking about repealing to get rid of an individual right, you got to repeal the 14th Amendment too. And that opens up a whole can of worms.
James, while I agree with everything you said, and I commend the eloquence with which you said it, as a practical matter, if there's a shift in the court, as a practical matter, and I deplore it, but if you're on the other side of the spectrum, that's the Autobahn to changing the status of whether there's an individual right to bear arms. And I'll be on your side, but as a practical matter, the likely consequence, honestly, of a Democratic victory in 2016, which looks distressingly likely to me, and I'll give you more fuel to the fire, I will not vote for Donald Trump under any circumstances. And to admit this to this audience, I'd rather have my legs devoured by a dog that's fasted for the high holidays. But it is likely that if there's a Supreme Court justice shift, this will be an open question again, and it's not beyond the realm of possibility that Heller's reversed, however much I would deplore that as a matter of constitutional law and interpretation.
So I'm not supposed to do this, but I'm going to. I'm actually a constitutional law professor myself. I'm the director of CU's Byron White Center for the Study of American Constitutional Law. I think DC against Heller was wrong, but I really hope that whoever the next justice is, the approach that they take is not to reverse Heller, but instead to take, I think, a more measured approach to understanding what reasonable regulations are than the current court would take. Because I think it would be deeply problematic if political decisions became that kind of football where, okay, we're just going to wait until there's a change in personnel and we'll shift back and forth and we'll fight it back. I mean, that I think would be really sad. So, but reasonable regulation. So
Justice White would be proud of you.
so back to reasonable regulation. A number of people have asked, would it be reasonable regulation to require, this question says some sort of safety device on guns to prevent accidental discharge or use by children. Another question here says, we turn our phones on with a fingerprint. How about requiring a fingerprint to turn on a gun? Would something like that be a reasonable regulation?
What about us old geezers that can't turn on their phones with a fingerprint?
You still have a fingerprint, though.
Yeah, but it doesn't work.
That was the original question in the Heller case, wasn't it? Was the lock?
The lock that effectively disabled the gun as a useful self-defense instrument. It took like an engineering degree from Georgia Tech to get the thing off of the pistol. So that would be an example of a regulation that effectively is destroying the right to self-defense, which is exactly what the Heller opinion said. You can make the regulation so cumbersome that you cannot exercise your right. A reasonable regulation allows you to exercise the right, but with reasonable guidance.
And then there was this issue that in Heller, the regulation was with respect to putting those kinds of safety requirements while the gun was in your own home. And so the question is then, well, can you put those kinds of safety restrictions on if they're carrying the gun outside the home?
Heller never reached that issue. The strict holding was self-defense within the home. There will be another case that reaches that issue. But that's all Heller talked about, was an individual right of self-defense in the home.
So there are a lot of other questions. I'm just trying to, we have about a little less than 10 minutes left. Most of the questions have focused on kind of what would be reasonable regulation, I think have come from a perspective of being skeptical about the individual right to bear arms. But there's a question here that I think is a good way to sort of end from the other side. The First and Second Amendments are commonly seen as a way of ensuring that power remains with the people rather than with the government or the military. Isn't removing power from the people counter to our democratic and American values? And I think, and I'll add, and therefore sort of trying to take a limited view to the Second Amendment counter to democratic American values. How would you respond to that question? And I think it's for all of you.
Well, again, using the First Amendment and the Second Amendment, because they are kissing cousins, as the Reconstruction Congress showed. You need the first one to protect yourself from bad people and bad governments, and then in extremis, you need the Second Amendment to actually vindicate your individual rights that the government is trampling upon. But all that means is that to the extent that the right is denied, yes, then it's anti-constitutional and it's anti-democratic. That is, it's taking individual rights away from we the people. But that leaves lots of room, short of confiscation, sort of disablement, sort of shutting down all political speech that you don't agree with because it triggers you. There's lots of room before you get there to say, well, we need to make accommodations. And all the Second Amendment is clear about is that you cannot disarm the populace through pretext or overt actions. That leaves plenty of room to exercise the democratic values of reasonable regulations in the interest of the health, safety, and welfare of the people. And those are the democratic arts that are lost when we all say, save us, Supreme Court, save us. That's what the slave owners said. That's why they wanted Dred Scott. Save us from the democratic forces that are going to outlaw slavery. And so I encourage the political arts and not the litigation approach.
It scares me to hear a question that is posed about the power of the people when you're talking about the Second Amendment right to bear arms. And the reason that just triggers some concern, some grave concern in my mind is because of another anecdote I'll tell you. When we leave here, none of you are ever going to want to come see us in New Mexico. But
I'm from Louisiana. I ain't scared.
yeah, in the midst of our little fight about the gun range in our community, we were chatting with a neighbor who was obviously actually the gun range was going to be on his property, and his position with respect to why they needed the gun range and they needed everybody to have guns and know how to shoot them in our area was due to the fact that they might need to have an uprising against the government, and therefore they would need that power. They would need their guns for that, to exercise that power.
The founders who fashioned the amendments to the Constitution and those who ratified them saw all of them, not just one of them, as inextricably linked and necessary to protect individual rights against government. A government that could deprive you of speech or deprive you of your property without just or adequate compensation, or could commit an unreasonable search and seizure, or could breach your right of contract, that was a government that would be able to take away any of your rights, and therefore all of these rights, including the Second Amendment, are equally foundational to well-ordered liberty. So if you value the amendments to the Constitution, you value individual rights, you have to take seriously the serious arguments as to why the founders believed that the right to bear arms was included in those rights, equally with the First Amendment and the other amendments that people tend to cherish more, but they're no more or less important than the Second Amendment for protecting our freedom.
So I think we're close enough to we've got about 5 minutes left, and rather than introduce any new questions, I guess I want to invite each of the panelists to just give us a sort of a 1-minute wrap-up of what you think we should take away from today's discussion. I'm going to start with you.
Okay. I'm just struck in listening to the conversation about how this is, to pick up on something that was mentioned earlier, the questions in the discussion are an example of the big, messy process of democracy and the need to find some way to balance competing and in many ways incommensurate goals. And so, I think the right to keep and bear arms is entrenched to the Constitution. It's politically inconceivable that will be overturned anytime soon. It might be retrenched by a flipping in the court. I think looking to the courts to solve this problem, I would agree with James, is exactly the wrong way to go. It's in fact, it's massively undemocratic. To me, on the other side, it's to organize and to identify and push for reasonable regulations that could win some favor and support. And it's hard work. There's no getting around it, but it's hard to see what else can be done to get to a better balance here.
I would agree completely that the takeaway really and truly is that the Supreme Court has allowed a lot of reasonable restrictions to be placed on, and for public health and safety reasons, that's exactly what all of us should work towards.
And I want to remind Boulder that a vote for Bernie Sanders is a vote for a robust interpretation of the Second Amendment.
So I also am not a member of the NRA, but to the gentleman who phoned in about a tsunami of brains and money, I am starting a new chapter called the Tsunami Chapter of the NRA, and I welcome your contributions and support.
All right, well, thank you all very much for participating.
Very well done.